Everybody, I'm getting everything set up here. Give me just a second.
Jim, this is Andrew. Can you hear me?
Mahe machita nikshea de maja de te de conse koikshe de combra mikshe akumbraga ka intati wakanda wakante. It's all these things I ask in your name. Intati wakanda wakante ishinka akuna. Amen.
Oh, thank you, Councilman Redcorn. I appreciate that. You bet. My name is Andrew Yates, and I am the chairman of the Osage Minerals Council. My duty tonight is to facilitate or possibly conduct this virtual public meeting on TERA. I've already got off to a bad start. I forgot to let my fellow council members know what the meeting was tonight. I apologize. This has been kind of fast acting. We decided last Friday that it was going to be either tonight or Wednesday night, and we decided on Monday or Tuesday. And so it's been kind of fast paced, and I don't know, I assumed everyone knew about it. And then I started getting calls. So then I've got everyone notified of the meeting after the Osage News had already run the ad. So anyway, we're trying to be transparent with this process. It's a tribal energy resource agreement allowing tribes to enter into arrangements with the federal government where they are able to take over certain inherent federal functions and conduct their own business in regards to governing and operating and managing their own oil and gas natural resources. For years, we've been hampered by burdensome overreach and overregulation by the federal government with our oil and gas industry in regards to NEPA, which is the National Environmental Policy Act. And I don't want to say it was enacted in around '89. I may be off on that a little, but our neighbors in the lower 76 counties do not have to face these obstacles, and due to that fact, we have lost several oil companies and potential investors in the Osage in the last few years. Right now, I am not going to say I support or oppose this TERA agreement. I'm here to learn and look at and hopefully this will be a first in a series of public meetings. Hopefully they go smoother. Hopefully my council's better notified. Make so that we can all make an informed and knowledgeable decision in the best interest of our Osage people and shareholders. We will be looking for feedback from both Osage shareholders and future shareholders, as I feel an action like this needs to be fully involved and supported by all that are impacted by this possible action. That's my opening statement. Like I say, I'm going to be trying to learn and make my best decision on behalf of the Osage people and shareholders. And at this point, I'd like to hand it over to anyone else that would like to maybe make an opening statement, or hand it over to Mr. Trumley. Mr. Trumley, we've tasked with being the project manager. He will be the one that's seeing this through from start to finish, and along with Wilson Pipestem. So anyone else need to speak? And I'm not sure who's running this, so I don't see any hands. I can't run it, so.
I don't see anybody raising their hands. So.
Okay. Mr. Trumley or Mr. Pipestem, I guess it's your ball now.
Okay, I'll get started. I just thank you, Chairman, for the honor of addressing our Osage head right holders and others on this important issue at TERA, and it comes as a part of a confluence of many issues that have really troubled the Osage mineral estate and the amount of revenues that our Osage head right holders receive. And there's many things going on with the head right that impact head right income to individual Osages. One is as you may know about, is the American burying beetle, which is a beetle that has been listed as endangered. Well, we got some good news today that the Fish and Wildlife Service plans to downlist the American burying beetle from endangered to threatened, which opens the door for us to have less impact on the Osage Mineral Reservation. We also are very close to finishing a conservation area agreement with the Fish and Wildlife Service that would prevent other endangered species becoming a problem in the future, where we could then use that as a basis for avoiding the problems we've had that have really shut down production in the Osage. So it's been a problem in a large area beyond us, but this ABB issue, as we generally refer to it, looks like there's some light at the end of the tunnel, and it looks like the light's pretty bright. So, regardless of what the final rule is and publication of this rule, and whether it goes to litigation, whether that federal rule is one that is going to take some time for the courts to decide, or will there be a stay on the final judgment of that, or, and honestly, whether if there's a Joe Biden administration that comes in and decides to change that rule, all those things are, things that could happen. So the Osages, through the Minerals Council, has created a new opportunity through this conservation area, and that's very close to being done. So we're maybe within a couple of weeks of having that finalized. So it provides some protection for this hopefully not happening again. The other thing is there's an environmental impact statement that is reaching its final few months of decision. And so that will be a very important document. So as you may know, there's surface land owner challenges to actions involving minerals production on their surface lands. And there's been challenges brought in the different courts on that issue. And so the question of NEPA has the National Environmental Protection Act, and having an EIS, either the final outcome could be very helpful or very harmful, depending on which way they go. And so the Minerals Council has been very focused on closing that process down in a way, or finishing that federal process at the highest levels of the Department of the Interior, to make sure that ends up in a reasonable place for the Minerals Council and producers, so we don't get slowed down too much by these federal processes. And I'll talk more about how the TERA can directly impact the NEPA process. We've also got existing litigation going on in the west of Pawhuska. Many of you know about the litigation against NL and Osage Wind, other companies. The United States brought an action against these companies for signing surface leases but not getting a permit with the Osage Minerals Council that was approved by the BIA, that would allow them to mine our minerals and use those as a foundation for these gigantic wind energy turbines. So I think we've all concluded that wind energy itself is not bad, but where you put it in one of the more beautiful places in the world, as far as I'm concerned, in the prairie west of Pawhuska, that is a issue that the United States, again, brought the action. They lost at the district court, then decided they weren't going to appeal, and the Minerals Council stepped in and brought that appeal to the 10th Circuit. It reversed the case. So now we're back at the district court litigating remedies. So, there's ejectment of those is still one of the issues on the table, other damages, other remedies there. So we're in that process. We've still in the discovery phase of that litigation, so there's still a ways to go. But all of these things impact what happens. Also, another very important happening occurred recently, where the Department of the Interior provided draft Osage oil and gas regulations to the Osage Minerals Council, a discussion draft of those. And I actually tasked out one of our associates to do a red line of the new regulations versus the old one. And they're so incredibly different that it was almost all red line. So we actually stopped the process of doing that because it was a waste of time. So we got a lot to cover there, but all of that could have a significant impact on the regulatory environment within which companies that come to do business with the Osage, in the Osage for minerals development, operate in. And so we have seen a federal government through different agencies come down, make decisions that have had a significant negative impact on the production of the Osage Mineral Estate. At this point, getting a permit to drill has been extremely difficult. So again, TERA could have an impact on that, and we'll have a discussion about that. So there's a lot going on right now in the world of the rules related to Osage minerals production. And hopefully we can get some positive outcomes on those matters. So it will make a difference in Osage headright holders' income. And so what the Minerals Council has directed me and my firm to do is all of this is a important effort, but ultimately we're talking, it has to end up in additional revenues to Osage headright holders for it to make sense. But Jim, you could go to the next slide, please. So on December 18th, 2019, the new rule on TERA was released by the Department of the Interior. Now, TERA, this idea, federal law that says that tribes can take over management of their energy resources the same way they do their surface land. So that's been around for a while, but tribes never took advantage of it because it didn't make sense to do. It just, the way the law was written, it just didn't make sense, including the Osage. So the tribes who were big in oil and gas, no tribe has sought to have a TERA, but under this new rule, the main part of it is that the duties that are carried out by the Bureau of Indian Affairs and possibly other agencies would be managed and taken over by the Osage Minerals Council, and in some circumstances, the nation through the executive branch. All of that has to still be sorted out, and I'll get into that in more detail. But that's primarily it, where you avoid some of the federal bureaucracy and some of these federal statutes that have significantly slowed down oil and gas production. Now, I know there's a lot of concerns that have been expressed by some Osage headright holders about, what does this mean for the Osage Trust? We have a relationship with the 1906, with the United States that's created by the 1906 Act and amendments to that act. And so the trust was established there where the United States is the trustee, the tribe is the beneficiary of the mineral trust, and the Minerals Council is the modern body that acts on behalf of Osage headright holders as the beneficiary to decide essentially questions of leasing and development of the mineral estate. But we'll get into that. Why I'll show you the language about why this is. This does not violate that trust. It would not undermine the trust relationship that the United States has with the Osage Nation through the Minerals Council. And then Osage headright holders have a separate trust relationship because of their headright and an IM account that once proceeds are distributed to individuals, they have a separate trust relationship that's independent of the headright or the Minerals Council. So I'll go over the process for the application of the TERA and then off-ramps. And what I mean by that is that there are, at any time in this process, the Osage Minerals Council can pull the plug on this if they decide that this is not something that makes sense for us to do. It doesn't make sense for the headright holders. It is, that can happen up to the very last day of the United States approving a TERA. And by the way, once the tribe and the Minerals Council submit this, the government has 270 days to consider it and decide whether to approve it or not. So this is a long process, it's involved. And so I'll get more into that. But also the roles and decisions of the Minerals Council, Osage Congress, Osage Chiefs. The Minerals Council cannot do this alone. Now, it doesn't mean that the executive or the Congress takes over this. It's not, that doesn't mean that at all. It means that for example, environmental reviews, which are already done, and there's already a process for that within the Osage Department of Natural Resources. It seems like it might make sense for them to carry out that work in this circumstance too, but that's for our leaders to decide once we get to a point of making a decision there. Otherwise, it will be a Minerals Council, largely Minerals Council process. And then uncertainties. I mean, there's a lot of questions about federal funding of this. So there's different funding streams we think that are out there, not only through self-governance contracts and compacts, but well, contracts, I think, in this circumstance, but also other federal dollars that we may be able to access that helps cover the costs of taking on these different responsibilities. Okay, next slide. Okay, so the new federal rule, this isn't what we're, the Osage TERA, but a new federal TERA rule. It basically says that you can create procedures to enter into an agreement for leasing, management, business agreements, rights of way, without approval of every single action. Now, right now, if the Osage Minerals Council approves a lease, the Secretary of the Secretary of the Interior's designee, the superintendent of the Osage agency, has to approve every single one of those. So if you've been in Minerals Council meetings and you've heard the interaction between the superintendent and the Osage Minerals Council, you realize that sometimes the superintendent makes decisions that the Minerals Council does not support. I don't know any other way to say it. So I can remember being a kid with my father, Browning Pipestem, who was an attorney for the tribe, coming into meetings, and it was sort of what happened. The tribal council at the time would ball out the superintendent for making decisions and tried to get the superintendent to make the right decision and do differently. So in this circumstance, that relationship between the Minerals Council and the superintendent would be narrowed a bit, but the Bureau of Indian Affairs would still have a significant role. I'll get into that further into this. So when Congress amended the Indian Tribal Energy Development Self-Determination Act, it said that tribes, like it has, this is a reflection of modern federal policy where this has gone. It used to be the Bureau of Indian Affairs just sort of ran everything, or the Indian Health Service ran everything. And we've seen over the last few decades that has shifted to the federal government passing laws that gives tribes the opportunity to take over functions, take over the federal funds that are appropriated for those functions, and operate them themselves. So this is an extension of that, an extension of self-determination over energy resources. So TERA was based upon something called the Hearth Act. And the Hearth Act is basically a surface lands leasing statute. So the Osage Nation already has an approved Hearth Act. So some of that infrastructure is already in place at the Osage Nation for doing this sort of thing, but it's only for surface lands. This would have to be for the subsurface mineral estate, which is really a much bigger, not only a bigger area, but a lot more asset, and would be a bigger step forward, a significant step forward. But also the law preserves the Secretary's trust responsibilities related to minerals and does not absolve the Secretary of his or her obligations related to the Osage Mineral Estate, including those in the 1906 Act and subsequent amendments. So it's by language. It does not absolve those responsibilities at all. In fact, it expressly says we continue those. Okay, next slide. So if the Osage were to create a TERA, the Minerals Council would have authority to approve leases, other business development agreements, rights of way, and related energy development activities that implicate the mineral estate. Now, exactly what that means, we still have to get through this process to find out which parts of this make sense to do. And I think one area that the 1906 Act prohibits the tribe from getting into is taking money from producers and distributing it to head right holders. So in other words, if the Osage Minerals Council signs a lease and that company drills and produces oil and makes payments to the Office of Special Trustee, which is a federal body, that would continue. The taking of deposits, the short-term investment of those deposits, and then the distribution to individual.
Chairman, may I interrupt for just a second, please?
Yeah.
Chairman, I just saw the Secretary of Interior assigned a new division for TERA Sweeney to they're going to take OST out in October, and then we'll have to adapt this accordingly. And while I'm speaking, I just think that we should be looking at all avenues, contracts, but when we go into 638 self-governance, that will have to be with a MIFA with the nation. That's just my thoughts. Thank you so much.
Okay. Thank you, Councilman Waller. And so, again, as I mentioned before, or just started to get into, that what we're talking about here, a TERA, if done right, and it has the promise that we think it might have, it would increase business activity in the Osage Reservation related to minerals. It would give authority to the Minerals Council to enter into to leases and other business agreements, rights of way. And it would establish procedures for environmental review. And let me tell you, don't underestimate this, because if you're a producer right now and you go into the Osage, you have to comply with NEPA. So, and so does the Minerals Council. So if you have if the Minerals Council approves a lease for, say, for oil and gas, that has to go to the secretary or it has to go to the superintendent for approval. Well, that federal approval triggers the National Environmental Protection Act. And with that comes a lot of federal responsibilities related to process that take time, and it costs producers money to meet those requirements. And so what this has the promise of doing, and it was meant to do that, is if the tribe takes this over and we create a NEPA-like environmental process, then we would do that on our own without having to go through a federal process where each one of those leases or actions triggers another NEPA process. And right now that is the state of the law, and it's causes a significant burden on production. And again, this is all driven by the interest in increasing Osage head right holder payments. So I know those of you who are on the call who may have questions, we're going to have time at the end of this presentation for questions and answers. We'll do our best to answer every one of those. Okay. So next slide. So again, as I mentioned about the process, the TERA automatically takes effect after 271 days. So, you're dealing with federal government, sometimes I'm going to shock some of you that they can be slow. The BIA can be slow. And so there's an old joke, that, Custer went off to Little Bighorn and he told the Bureau of Indian Affairs before he left, don't do anything till I get back. So in this circumstance, we see delay at the Osage agency and up the line in this federal bureaucracy. And so in this circumstance, Congress in its wisdom decided, well, once a tribe submits a proposed TERA, they have 9 months to consider it, which is a long time, but there's still a lot there. So if you don't make a decision after 270 days, on the 271st day, it becomes approved, becomes deemed approved. So also, federal government, you can't just say, okay, I found a typo in your draft TERA, so we're rejecting it on that basis. No, there's 4 specific reasons that the department can say no to a tribal TERA. 1, the tribe fails to demonstrate capacity. You have to demonstrate we have the ability to do this. We have the capacity to do this. Now, that is specifically defined as 3 consecutive years without material audit exceptions, contracts or compacts under the Indian Self-Determination Act, or having an approved Hearth Act. Well, we meet all those. The Osage Nation meets all those requirements, not just one of 3, but all 3. So the second is that a provision of the TERA would violate applicable federal law. Well, for us, that's largely the 1906 Act, right, and its amendments. So I've heard some people say the 1906 Act doesn't apply anymore after the Osage's created Constitution. I'm telling you, that's just false. The 1906 Act is extant law, and we still operate under that. The federal government agrees with that. And so there's the protections and benefits and the strictures of it certainly still apply. And so the Osage Constitution, to the extent it has places where you read the Constitution, it intends to keep all those things together and fit together, although there's some rough edges, and I'll talk just a little bit about that. And then the TERA requires the BIA to stay involved, right? So you can't just say, bye-bye, BIA, you're out of here, and that's it. You won't hear from us again. That's not what happens. You have to do reporting to the BIA on your activities. They have to evaluate what's going on, and that's because the trust relationship still exists. So the BIA is still going to be looking over the shoulder of the Minerals Council and the tribe on this, whether we like it or not. And again, the TERA does not have to include any of it has to include there's some specific requirements that have to be in a TERA, including how your environmental review is going to work. So basically the Congress said, tribe, if you're going to take over these important environmental processes, evaluation processes, if you're going to take that over, we're going to require you to put that in your rules. So we have to approve that action. So there'll be a negotiation about that. But again, those procedures are already defined in Osage law through the Hearth Act, and they've been approved by the United States. So we'll have to see whether or not there's any changes here. But our presumption going into this is that will essentially be the same. Okay. Next slide, please. So in the world of environmental protection, categorical exclusion is an important tool in avoiding a lot of process. So if you meet certain regulatory standards and it's sort of the same activity that's been going on there for some period of time, there's not a change, categorical exclusion allows you just to say, that's it, that's enough right there. We've checked the box on environmental process. And so on the trust responsibility, the trust would still fully be intact. There's one area that I think is you have to really focus on though. So if say the Minerals Council under a TERA would enter into an agreement on an oil and gas lease and agreed on certain terms, and boy, they really hit big. And the Minerals Council could not sue the government for making a bad decision in a negotiated term, right? And really, it would be extremely difficult to sustain that claim anyway, having litigated against the United States for 8 years. I know what that's like trying to sue in the Court of Federal Claims. And so, to me, that is something that is a significant exception, but that should be noted, but as a practical matter, has really pretty limited effect. So it also allows for a 10-year term for oil and gas business agreements. So you can't give a company a 99-year lease. I mean, it limits the ability of a tribe under a TERA to enter into a agreement of this length of time. Also, I don't know, Jim, somebody's saying that they're not getting the slides. They're just still on the first one. I don't know if that's a problem that you can fix, but if we can go to the next slide, please. Okay, so one really big issue is to the extent the federal government has funds to carry out the functions that it carries out now. Under a TERA, the department must give those funds to the tribe to use for its operations. And so it's different. It doesn't just say under the Self-Determination Act, which is the federal law that creates a pathway for the United States to give money to the tribes to operate certain programs. It's a little bit broader than that. Now, the function of it will be through a 638 process, but it will be, we think there's other pockets of money that may be available there. In fact, we'll be, I think not with the superintendent, but with Indian energy people in Denver, which is where we prefer to be negotiating on this because they're a better understanding of energy development there. So next slide. So this is kind of the general process. So you have a pre-application consultation. So the Minerals Council did have that consultation with federal officials. It was the Denver people, right? It was John Blackhair and Christina Clark and people who work in minerals development who are friendly to this sort of work. In fact, they suggested that maybe they would open a Tulsa office after they came to visit the tribe on this issue. And you know, the things that must be in that application, here's some of the things that are required, like the types of energy resources that we would want to develop. Now, we could look to oil, we could look to gas, or you know, you could have surface land resources like wind and solar that you could take over. Now that would be, you would have to figure out which entity within the Navy doing that. Now the one thing we cannot take over is some generally referred to as inherently federal functions. I mean, things that are inherently federal that we cannot take over. And so there was a significant fight over whether the tribes could take over the permits to drill. And that is a important, obviously when a producer comes and says, I want to lease some land, I need a permit to drill. Ultimately we were at the forefront of that fight, and the department did say, yes, the applications for permits to drill is something a tribe can do on its own through a TERA. So now again, we've got the 1906 Act to deal with, and it has some strictures in there. I think it's mainly related to management of funds, which I think we cannot do. But that's one of those, that's sort of generally what's going on with inherently federal functions. We have to identify the lands, which I presume would be the Osage Reservation. The scope of the administrative activities we want to take, kind of pick and choose what you want to take over and not. So we have asked the Bureau of Indian Affairs and Department of the Interior, other officials, to walk us specifically through what procedures they follow. You know, it's my impression that there's not a wizard at the Osage Agency that is brilliant in oil and gas development, that is so smart about stuff that we would be making a mistake by killing that wizard through a TERA. I think it's well-meaning employees, federal employees, who are following procedures and doing their best to carry out trust responsibilities. But you know, and those on the Minerals Council who've actually worked in this area know a lot about the details of what happens at the Osage Agency. And usually, I think the answer is this is not something that we should be afraid of. Okay, next slide. So I want to talk to you about the legal framework for doing it, because this is important. We've got the Constitution, that is Osage law. We are bound by that. The 1906 Act and amendments and the existing regs. And by the way, I mentioned those regs are going to be under reconsideration again. We've got those draft regs, and there's substantially more to that draft regulation than the existing one. And then there's the TERA rules. So next slide, please, Jim. Okay, so the Osage so here's an interesting provision of Osage Congress, Osage Constitution. It says obligation of the Osage Nation Congress, okay, 3-branch government. As you know, the Minerals Council is an independent agency. That in a minute, but the Osage Congress shall provide for the utilization of all the natural resources, and oil and gas is a natural resource as a part of that definition of the law, for the maximum benefit of all Osage people, then I was trying to understand what that meant. And I Googled those words. And essentially, if you look at what the Alaska Constitution almost reads exactly the same way. So it appears that when the Constitution was being created, Alaska was, they cut and pasted that and changed it a bit. But that doesn't work for us because we've got head right holders and we've got an interest in them. But I think it meant to say there's this broad category of natural resources and the Congress has certain authorities. Okay. Next. By the way, before you change there is an effort by a group of Osage head right holders who are wanting to make changes to the Constitution that would kind of smooth this out. I think that's been a productive effort, but this pandemic has caused the slowdown of that. And so, but it would help deal with parts of the Osage Constitution that have, as I mentioned earlier, kind of rough edges. Okay, next slide. So Minerals Council general authority under the Constitution. So it makes clear that the Osage Nation through the Minerals Council shall be respected and protected, particularly the income there, okay? What the Constitution does, and I'll show you in a number of ways, it protects the interest of Osage head right holders to receive funds. So I know that ever since I was a kid, there's always been a worry that some entity is going to try to take away Osage head right holders. And, we've learned over time through legal cases and otherwise that the only entity that I think could do that is the United States Congress. And I've never heard that they have any interest whatsoever in doing that. So any effort by anybody to take away Osage head rights, I think this is meant to reaffirm that the Constitution doesn't allow that. And it says so several times. So, and then it also makes clear that the nation, through its Constitution, creates the Minerals Management Agency designated as the Minerals Council. So it has the obligation under the Constitution to discharge these obligations of protecting rights of Osage citizens who receive minerals proceeds. So again, it creates another layer of protection, but it also makes clear that to the extent mineral matters are taken up in the context of the Osage Nation, that the Minerals Council is the body with authority to make decisions related to those issues. Okay, next slide. So what does that mean more specifically? So the Minerals Council has leasing and other forms of development authority. So certainly the Minerals Council has been doing this for many years, from the time there was a tribal council to the Minerals Council, to approve leases, okay? So we have an initial authority as a trust beneficiary through the Minerals Council to make a judgment on whether a lease is fair or not and should be entered into. And then propose other forms of development of the mineral estate. So the Minerals Council has this authority, these authorities that are pretty broad in relation to minerals, and they're exclusive to the Minerals Council. So I think that forms the basis on the Osage law side for kind of who would be carrying out most of these duties, right? So there's this next provision that leases that are approved by the Minerals Council, the chief has 5 working days to say that, no, this violates Osage law, and then there'll be a dispute resolution process. To my knowledge, that has never happened since the Constitution was adopted, but it still seems like maybe that's worth rethinking. I think some of the head right holders who are bringing this constitutional reform process are taking particular focus on that authority. And then also that, we are in a federal trust created by the 1906 Act, right? We're talking about federal statutory law. This is not, the Minerals Council, whether it wanted to or not, is not free to just make any decision it wants in this area. Every lease, every agreement has to be done in compliance with federal law and the laws and regulations of the Osage Nation. So there's not much limiting. Osage law does not really limit the authority of the Minerals Council. And in some ways it can't because of the Constitution. But it also does give the Minerals Council administrative authority to deal with some of these issues as well. So the Minerals Council seems to be a fit here as a matter of Osage law. Okay, next slide, please. So again, protection of minerals proceeds. The Constitution makers here said, well, we've heard concerns from head right holders. They're afraid that this is some effort by the nation to take away their head rights. So they say it again. The government of the Osage Nation shall ensure the rights of all members of the nation are protected to their head right income. So if all the Osage government decided we want to start taking head rights back from people, the Constitution itself prohibits that from happening. So in fact, the nation cannot create a law or ordinance related to minerals that conflicts with federal law. So again, our tribal law prohibits activities by Osage governmental officials that would interfere with these matters. And that is a reflection of the 1906 Act and over a century of minerals development on the Osage Reservation. Now the next section, the Minerals Council, this is again in the Constitution, is recognized as an independent agency within the Osage Nation for the sole purpose of continuing the duties to administer and develop, those are two key words, administer and develop the Minerals Council in accordance with the 1906 Act. And then, Councilman Myron Reddy appropriately corrects me sometimes when I say just 1906 Act. So now remember, it's the Osage Allotment Act. And that is correct. And then amendments to that. And so the Minerals Council doesn't have legislative authority, but it does have administrative authority, and it can create, rules and regulations, procedures, that sort of thing. Next slide, please. So then let's look at the 1906 Act, a couple of key provisions there. So these provisions give the Secretary of the Interior broad authority to prescribe regulations related to the Osage Tribe of Indians, which we now have decided to call ourselves the Osage Nation. And now that all funds belonging to the tribe and funds that may become due shall be held in trust. So that is highly unusual provision. The first one's actually pretty common for tribes. The second one is highly unusual because any revenues that are produced from the mineral estate, we have a pretty good claim that all of those are trust funds that must be paid to head right holders. And that will make a difference here in this TERA process. Okay, next slide. So this is sort of the same provision, expanded a little bit more. All the funds that are hereafter found to be due, and it will be paid out and segregated, paid to the credit of the head right holders. And that all things necessary, again, this is a broad provision where the Secretary can the Secretary of the Interior can carry out and do broad authority and when it comes to Osage minerals matters. So that's what Section 12 says. Okay, next slide, please. So we've got this existing federal regulation dealing with leasing operations, cessation of operations, plugging, that sort of thing, requirements of lessees, penalties. All that's being rewritten now, but it is still the rules that we operate under. Now, the important part about this new regulation is if we do enter into a TERA, we would need some provision in the new regulation that makes a place for us to say, these federal rules apply unless the tribe adopts a TERA. And so, that is something that we just started the process of dealing with that long, regulatory reform effort of Osage oil and gas regulations. Okay, next slide, please. Okay, and some final thoughts. So, a TERA provides a new pathway for greater efficiency in the management of the mineral estate. It creates some legal advantages, mainly through NEPA avoidance. Again, those environmental reviews that can be quite onerous and expensive. It gives you a pathway to, if you create your own process, you avoid the federal trigger of another NEPA action. Now, as Chairman Yates mentioned, there's a lot of questions that we need to have answered along the way when it comes to the federal government. You know, funding is a big issue. Some of the negotiations may be about certain authorities that we think are appropriate under the 1906 Act to take over or not. Questions about what, you know, we think, you know, the environmental process is probably, there's already within the Osage Nation that does that, whether they should continue to do that, that sort of thing. And then the off-ramps. Again, I want to just say again that the Minerals Council's made clear that if at some point they decide that this is not worthwhile, then we can just pull the plug. There's at no point are you really so far down the road that even after you've submitted your application that you can't withdraw it. And I will say, even after you submit a TERA and it's approved, that can also be turned back over to the BIA. Again, their role is still continues on through all this. They provide oversight, and you have to provide reports to them, and they have to monitor your activities to decide whether or not you're violating that trust or violating federal law or even violating your own TERA. So, so at this point, I would be glad to answer, or maybe, I don't know if you want to have any comments from the council or you want to just go right into questions and answers. So Chairman, I'll leave that to your discretion.
I'm fine with whatever happens. I mean, this is the first one, and we'll just see if anyone wants to ask questions. I think Mr. Trumley has the control on who's raising hands. Jim, you're muted.
Okay. Yes, Chairman, I do have controls of that, and I do want to open it up for questions from the floor. Before we get started with that, there were actually some questions that were submitted in advance in writing, and I think distributed to the Mineral Council. So what I'd like to do is I would like to read those and allow the councilman and Mr. Pipestem to answer those so that we can have them recorded and make sure that those get addressed as well. The first one is, will annuitants' money be used to fund any part of TERA?
Okay. Well, so I think annuitants funds, now if you're talking about after those proceeds have been distributed, absolutely not, right? But if you're talking about the $1 million that is drawn down from the Tribal Trust Fund to the Minerals Council, I think that's a question for them to answer at that time. But I think that gets into the question of how is this going to be funded? And I will continue to say that is an area of uncertainty. And if the federal government does not have funds on an annual basis for the Minerals Council to and the nation to do this work, they may decide, hey, it's not worth it. We'll leave this in the hands of the BIA to continue doing what they're doing. But you know, that we'll have to make a decision. The Minerals Council will have to make a decision, actually, with the Congress and the Osage Nation and the chief, about whether to move forward with this. So. But I will say that funding of operations under this is still a question that we've got a lot of uncertainty, and we won't really know the answer until we get into this further with the Department of the Interior.
Okay. The next question that was submitted is along that same line, and it's, will monies be taken from the Osage Tribe / Nation account where at BIA, where all of the annuitants' monies is deposited from royalty interest, etc., before distribution to IIM accounts?
Well, I think under federal law, we can if we wanted to, right? So, I mean, we're limited to that $1 million of drawdown for minerals purposes. So the TERA does not change that part of it. But the question is, once it becomes funds that are available for the Minerals Council, whether they decide to allocate some of that for purposes of the TERA.
Okay, the next question was, at what significant impact I'm talking about money the annuitants will see from TERA.
Well, I will say that the Minerals Council has repeatedly said if this does not lead to more income for Osage headright holders, then we probably just would not be interested in doing it. But as we've talked about here at the beginning, we're at a time where production is at a low. I'll let Minerals Council members, if they want to discuss this, talk about kind of the historic nature of where we are. We've got all these different federal strangulation of production going on through the Bureau of Indian Affairs primarily, but also the Fish and Wildlife Service through AB&B. And I will say these Minerals Council have been clawing and fighting to get out of that. Now, again, that is something these are all federal authorities. We've got difficulties with trying to get federal records, well records, so producers can access and make judgments on whether to lease and drill or not. There's a lot of things that have made dealings within the Osage more difficult that are federal decisions. So, as I mentioned, we're on the cusp of solutions on the American burying beetle endangered species question. We think this EIS, we're down to the end of that, where that could either be a pretty good place or not. So we're trying to make sure we close on that in a smart way, and we've got good consultants on that. And and now we have these new regulations that have been proposed that we have to try to digest and understand and make decisions on. So a lot of the regulatory environment, where if a company is saying, should I go and sign a lease with the Osage Minerals Council, they have to evaluate the regulatory environment. How much is it going to cost me to go in there and do business? Right now, that is an exceedingly high cost. So those federal decisions have caused a slowdown. The Minerals Council is fighting like crazy to try to, deal with this laundry list of issues that it's been presented with. And a TERA would be, has some advantages to help solving those. Now, it wouldn't be a cure-all. It doesn't mean we enter into a TERA and we can go start shooting, endangered species that live within the Osage Reservation, but it does mean we would have significantly more authority and be able to make decisions that were advantageous to Osage headright holders.
Okay, thank you. The next question is, what monies will be used to pay the Osage Nation executive to run the minerals?
Well, the Osage Nation executive would not run the mineral estate. I mean, that is, as I mentioned, under the Osage Constitution, that is a power specifically delegated to the Minerals Council. So I think, I know that over the years, there's been tension since the Constitution about, what role will the nation have in minerals? And the Constitution itself, so tribal law, creates barriers to that. This is an area that is heavily involved with federal law, 1906 Act and Amendments, federal regulations. And under our Constitution, that cannot be violated. But it also makes very clear that minerals decisions are to be made by the body elected by the Osage headright holders, and that's the Minerals Council.
Okay, the next question is, will the OMC be done away with?
Not at all. I mean, in fact, if the Minerals Council would probably have a much more significant role, there'd probably be more staff. There'd have to be some, there would have to be the creation by the Minerals Council of different departments to manage some of these things. So I think, Jim, I think some of the Minerals Council members may be wanting to address that. Is that right? I said Councilman Redcorn.
Yes, it's back on, Jim, please.
This Mr. Redcorn, this Councilman Redcorn, I wanted to ask Mr. Tremblay if he can kind of blend questions from our people that are online with the questions that are, and they're going through that whole list, give our folks that are online a chance to ask some questions. Maybe.
I'm very open to however you want to do it. I'm just trying to facilitate.
That's all right with Chairman. I think take a few questions from our audience, and then maybe Jim will throw you here and there until we get them all.
Sure.
Did Councilman Waller have something to add?
I just need to back in on the video, sir.
Oh, okay.
$3.
I have a hand up on iPhone. I don't know who that is.
Not mine, sir.
Jim, do you see a hand up on iPhone? It doesn't have a number.
I do not see a hand. Wait,
I think it's Sherry Mashburn. I think I see her. Is it Sherry? So if you,
can you hear me?
There we go.
There you go.
I can hear you now.
Okay.
Yeah.
Kind of got a couple of questions. The TERA eventually will be a good thing for the Osage Nation. It's going to take a long time to get it from what I understand. In the meantime, because of our oil and all the restrictions that we've had in production, do other companies that drill for oil, do they have these same federal regulations they have to deal with to go to get the oil, or is it just because we're on our reservation and we have the beetle living with us?
Yeah, I think it's a great question. Now we have the 1906 Act, but there are other federal laws that apply to other reservations. So if you look at Southern Ute or Hickory Apache or related tribes of Mandan, Hidatsa, Riccara, Hopi, Navajo, they have other laws, but it still requires these federal, the Endangered Species Act, NEPA, all these federal laws still apply there. So they don't get to avoid them either. But it's been an ongoing issue for many years about the number of steps and the time it takes for a lessee or a lessor to be able to drill on trust lands. Now we're dealing with a trust asset, meaning it's held in trust by the United States for the tribe. It triggers all those federal requirements because they're really managing it. Right now, I think there's a lot of confusion that, okay, the Minerals Council, they approve a lease and then they carry out everything and then they send us a check and all that. It's really, we sign the lease and then the BIA takes it from there. And now there's been times where that's been worked just fine. Some might, I don't want to say that. People can disagree about that, but at least the leadership at the time was satisfied with how the Bureau of Indian Affairs managed managed the mineral estate. But, that's, the Minerals Council, if you watch these meetings and dealings with the BIA now and what's been going on, it's been a different environment, one that's really shut off development. So again, I think it's driven by increased payments to head right holders.
I might add a comment. But Mashburn is correct. You have federal leases going on in the ocean down there in Louisiana, Texas, and the Gulf. Out on the East Coast, those are all federally driven leasing activities, just like ours. It's like Indian land. Trump is trying to open up the Arctic area, and that'll be a federal activity. So you are correct. All these kind of run in line. What Mr. Pipestem is probably well versed in the Osage is that he's correct. The 1906 Act is unique to us. Not only Indian tribes can operate in activity, oil activity and energy, but they don't have the 6 Act like we do. So they have the general rules they have to comply with. So this gives us what Mr. Pipestem said. It's unique, it helps, but also it's a balancing act. But the good thing is I think we're in the driver's seat when it comes to the 06 Act. And then if we want to make change and incorporate TERA activities, we have a pretty good team being Mr. Pipestem and the folks that are involved around us as far as dealing with the 06 and ensure we get a good product if in fact we decide to go the TERA route. Thank you.
Wilson?
Great.
Wilson? I'm just reading with Mr. J.D. Schatzwell. he has a question. I'm just going to go ahead and read it. It says, is there a brief pro and con to doing this? And, you know, this is probably one of the reasons why we are getting input from the shareholders. I mean, listening to us is one thing, but that's what we want to hear from our shareholders. And as we continue to have more of these webinars, we can start asking a lot of great questions surrounding this, because ultimately this comes down to, number one, we are not giving up our mineral state. I hope that's just really clear. I think you've done a great job, Wilson, of in your PowerPoint of getting that through. But the other thing is, it also opens up for doing this on our own terms, but we're still regulated with the inherent federal functions. Is that correct? But what we want to do is ultimately increase development on the Osage, and this is one tool that we can use to do it. Wilson, do you want to go over some of the pros and cons?
Sure. You know, I would say at this point, there's some pros, there's some cons, and then there's uncertainties. Right. And if there was a list of pros, I would say NEPA avoidance. Now, if you're a producer, the idea of having to deal with the tribe instead of a federally triggered decision on NEPA, that's an advantage. So a lot of that authority would be carried out by the tribe, and presumably the tribe would have a greater interest in doing what's in the best interest of the Osages on that. I think that it would also create efficiencies that we could create that the federal government is limited by. So right now, you know, trying to change federal regulations related to Osage Minerals is a multi-use process. It's controversial. Ultimately, that would be decisions that would be made by Osage elected officials led by the Mineral State. I believe that the Minerals Council, that those rules could not be changed without the Minerals Council. We have, under the Constitution, we have authority over those issues. So that would be something that, you know, I think I've heard some express worry that, well, what if the Osage Congress and the chief just pass a law and it bypasses all the Minerals Council and they take over? Well, under the Osage Constitution, they're not allowed to do that. So, and it's reaffirmed in several places within the Osage Constitution that that authority lies with the Minerals Council. So, you know, the Minerals Council, as you know, is elected exclusively by Osage head right holders. So they're the decisions on behalf of the tribal beneficiary there. Councilwoman Gray, does that answer your question?
Yeah, as we go into further
the pros and cons.
Pros and cons.
I'm sorry. I think the avoidance is one clear one. That was what Congress intended for this to be, was a way to avoid federal NEPA process where tribes could take over, which there'd still have to be environmental process, of course, but at least it would be done at a local level in what we would expect would be far more efficient, in a far more efficient way. And then with regard to other processes like permits to drill, which, you know, how Minerals Council, how long to get 8 days?
A year.
Year? Is that right?
She's talking 120 days. She is Robin Phillips. She's trying to work down to 90 days. That's her goal. Right.
So, I mean, if you can imagine, you're trying to do business and say, okay, I want a lease. Now I've submitted all the information. It just takes a long time. Because at ABB, there you can't hardly get a license and a permit to drill. So that would be one of the things that the Minerals Council could take over. So I think, generally speaking, efficiency in the minerals management process that currently does not exist very well. I think in part that's due to people in the bureaucracy, but also federal laws that apply here, particularly NEPA. Some cons, I think there is the one thing I mentioned, that if the Minerals Council negotiates a bad deal, you're stuck with that deal. You say, okay, a company comes and says, all right, we'll produce oil and you can get $15 of that $100. Minerals Council says, no, we want 20. but they agree on 17.5, right? And then all of a sudden they hit huge. And the Minerals Council can't look at the BI and say, we're going to sue you because you should have never let us do that. Well, I don't think it's very easy to accomplish that anyway in the court decisions that are out there now. So that is one thing that I think you could consider a con, as you give up that right to sue the government for your own bad decisions. If it's a negotiated term, it's a very narrow area. So I would say that that is a potential con. Now, I would put this under the uncertainty area, but the funding is a big deal. It's a big issue, and we just don't have answers on that yet. If that ends up being so insufficient that it's going to cost the tribe millions of dollars to do this, then yeah, they may decide to pull. But got to go explore that with the Department of the Interior. Get away from Robin Phillips alone and get to the higher echelons of the department and see what we can work out.
Wilson, if I might add, just real quick, FOIA, I believe, will also be a pro if the TERA happens. We are very hindered with FOIA and getting information to us, to producers, about our asset. And I believe this might be an avenue to also benefit, be a pro to get our information and able to distribute. It's been proven that once they decide to hand it over to us, we're free to send that information about to our customers and whatnot.
Right. So, yeah, I mean, I think definitely that's something we have a big problem, regulatory problem that we try to solve, which is access to well records. So potential business partners will have information about whether or not they want to do business with us, and they can make judgments on where they might be able to find certain minerals.
Very good question.
Are there any other questions? Well,
I might add one comment if I can, Chairman.
Go ahead.
August the 15th, 2015, the Osage Minerals Council won a federal court action that his last comment is that there is nothing that impedes the 1906 Allotment Act as amended. I think this opportunity, and that's why it's been so discussed on our side, is that we're not telling what the nation's going to do. We need to derive what the Osage Minerals Council is going to do, and then we go to the nation for laws that take the body to take care of us on NEPA, NAGPRA, the FOIA, and I think the council's done real well on that. With that, Chairman, I got to go to the oldest rivalry in Oklahoma. We're going to go get us the Tigers. Thank you all. God bless you.
Way we not.
Okay, so if there are no more questions, this will be recorded and will be posted by the Mineral Council, I assume on the Mineral Council website, or they post those things. And we will have more of these going forward, and I promise we will have better advanced communications. So I would like to thank everybody for attending. Yes, Councilperson Gray.
Muted.
Oh, you're saying bye. Okay. Bye, everybody. Thank you.
Thank you.
Thank you. See you, council, tomorrow morning, 10 o'clock. Thank you.